I'm looking to draw on your experience and some of the parallels, but also some of the contrasts between the legislation that empowers your office. With respect to the Conflict of Interest Act, it does not allow for the recommendation of prime ministers, or the prime minister or ministers to be removed from office for ethics violations, even in the case of using offshore tax havens or serious breaches of the Act. Do you believe that you're having the ability to recommend removal from office of ministers is a necessary deterrent for serious breaches of the legislation that you oversee?
Je vous remercie pour votre question.
Thank you for the question. I have understood that you want to know whether or not we have those kinds of measures in Quebec. The code applies to ministers and MLAs, so it is legislation for all elected officials, and I can recommend sanctions for any breaches to the code. For the sanctions, they are included in the code, so it goes from a reprimand, and they can lose their status as a member of the Legislative Assembly. So in Quebec, I can recommend a sanction or fines. There are different levels. There are 8 potential sanctions, and this is only a recommendation that I can make. It would be up to the chamber to decide. For ministers and for members, I could recommend a sanction, and the sanction depends on the significance of the breach, and an analysis must be carried out to decide which sanction, if any, needs to be imposed.
Do you think that your ability to recommend sanctions that include fines, monetary penalties, but also include the ability for you to recommend removal from office for serious breaches, do you think that that contributes to both the deterrent effect of that power, but also do you think that it contributes to public confidence in the system that you're responsible for?
Je pense que certainement
I think that the ability for the Quebec Commissioner to recommend a sanction, even if it's only a recommendation, does put some weight on a report. The analysis will be carried out on a case-by-case basis, and so that is done before the recommendation of a sanction. I cannot speak to the public's perception, but it is something that is included in the code, and it is something that I have to navigate, whether or not to apply sanctions.
Should legislation concerning the conflicts of interest of reporting office holders ensure that there is public reporting, for example, with ethics screens? Should there be reporting to the public on when the screen is used and what issue triggered the use of the screen?
pense que les filtres anti-conformité
I think that these ethics screens are an excellent measure. I think that it was part of one of my recommendations. Currently, our code does not include a screen. I can ask a member of the National Assembly to put in place measures, but that is not made public. I think that it is a good thing for these filters to be made, these screens to be made public. That said, I'm not certain that using this screen would build public's trust. I believe that commissioners need to put in place measures and make recommendations to factor in the public interest before an individual's interest. We need to see whether or not measures were put in place, but from that to having constant surveillance, I think that it's up to those who are subject to these rules to follow them. Thank you, Commissioner Mignolet, Conservative Party. The next.
Thank you, Mr. Chair. Thank you to the witnesses. I want to ask Commissioner Motherwell a little bit about your use of ethics screens in the province of Ontario. First of all, is there a specific statutory mechanism or legislative scheme with respect to setting up such screens, or are they part of your general powers as Commissioner?
They're part of the general powers.
Okay. So who administers ethics screens in Ontario?
It depends on the type of screen. And so, for example, screens, as I said, we tend to use across the spectrum. So we would advise a screen for an MPP. We would advise a screen for a minister. We would advise a screen for minister staff, that is for exempt staff, political staff. And we could advise screens even for deputy ministers. And therefore, within the realm of each of those groups, the administration will differ.
So can you give some examples of who would administer screens?
Certainly. So let's deal with a screen that has been recommended for a member of cabinet. In that case, generally these situations arise because they come out of a request for advice from me to the minister with regard to a certain situation. As I said, most of the time when we deploy screens, they're related to a family member who may have, for example, have a business that's a stakeholder of government. It may be about a relative, it's about a friend. They tend to be deployed for relationships. And therefore, I would make the recommendation that an ethics screen be implemented at cabinet. That recommendation then goes to the minister who shares it with cabinet office. And cabinet office assists in the preparation of the screen, and also oversees in the implementation. One of the things that I have asked routinely of ministers, because I mentioned at the outset that I meet with every member. And so when ministers come in for their annual meeting, one of the things I will ask them about is about the screens and what happens when they're at cabinet and they're tapped on the shoulder, essentially, and advised to leave the room. Some ministers have many screens, some had none, but in those who have several, they tell me that they sort of turn the page of their virtual binder. It is blank. Someone does tap them on the shoulder, advise them and say, you are to leave the room. They have no idea why. They leave the room, the matter is handled, and then they are advised when they can return.
So when the screen is triggered, are there any mechanisms in place to provide a level of transparency, to provide the assurance that the screen is, in fact, being used as it was intended to be? And I guess as part of that question, to what extent is your office involved in seeing that the screen is actually working?
We're not involved in that aspect at all, although it is, as I say, something that I will ask ministers. And when I have the opportunity to speak with Cabinet Office officials, they can advise me that a screen has been put in place and has been implemented. But if the question is about, do I know when it has been triggered, when a matter is before Cabinet, where a minister may have been asked to leave the room, I am not informed.
There are no other transparency measures in place. It is left to those who have been tasked with administering the screen and the public office holder to see that it is working. Is that the case?
Yes, it is. And as I said, it's tasked with career public servants who are working within Cabinet Office.
What about political appointees? Are they involved in administering of the screens?
When you say political appointees, do you mean, for example, individuals who would be appointed to chairs of public bodies, that kind of thing?
I'd be referencing, for example, political staff.
With political staff, it would be deployed at a different level, obviously, because they're not at the cabinet table, and therefore
sorry, just to
deployed
clarify,
within the ministry. Right?
I mean political staff within a minister's office.
Yes, and so they would have done this in consultation generally with the deputy minister, but again, they're able to tap into the resources of Cabinet Office for the drafting of that screen.
No, I mean, would they be involved in administering it for their minister,
no,
for example?
Not to the best of my knowledge, no.
Okay. Thank you.
Thank you, Mr. Cooper.
Thank you very much. Thank you to both of the commissioners for being with us today. I'll start with Commissioner Mignolet. Ethics focuses on what should be, and we can always say that ethics requires more effort than law. I've heard from you that values and principles can be very useful, and it's not because there is no provision in a legislation that behavior cannot be questioned. And we could focus on the immorality of someone's actions. And I would like to come back to this matter of balance that you mentioned earlier. You stated that there are expectations and you need to strike a balance between respecting one's privacy and following the code. How do you strike that balance? I believe that the code that I need to apply includes measures to help me find that balance. We have clear values and principles, and that's how the code starts. There's a balance thanks to the information that is requested. And so I expect transparency, and I have access to that transparency. The code allows me to have access to all the information that I need in order to give advice. And I do have powers for investigation as well. But in trying to give advice, I have access to information. And I believe that transparency is of the utmost importance so that I can properly do my job. But there needs to be a balance. We receive information on people's interests. I can make a request for more information if I need it, but it's only a summary of interests that is made public, and I think that this allows for finding a balance. It's a matter of trust, again. The main goal of any code, of any legislation, is maintaining the public's trust, and in order to do so, our role as commissioners is to facilitate that trust. Canadians need to understand that we have all the tools at our disposal in order to carry out our work, to give advice, and to carry out investigations. Thank you for your clear response. Earlier, you mentioned the moral obligation to go beyond the appearance of integrity. You stated that it is crucial. The Ethics Commissioner has asked us to extend the application of legislation to conflicts of interest, but also to an apparent conflict of interest. He has proposed a definition that says to an elected official, you should not find yourself in a conflict of interest, but you should also not find yourself in an appearance of a conflict of interest. How would you see that? Do you think that it would be important to be able to codify that recommendation? The notion of an appearance of a conflict of interest is important, just as the appearance of justice is important for justice. But the Quebec Code does not define a conflict of interest. We don't have a definition, whether it be real or apparent, but we need to understand that a conflict of interest is important to be noted, and the Quebec approach is different because it is not defined, but it is included in some of the measures and can be applied. And so when you investigate, it's because there's an appearance of a conflict of interest before you get to say that there is in fact one, because often the question is whether or not there is an actual conflict of interest. Sometimes it might be quite clear, but you can investigate even if no complaint has been made. Yes, I can initiate an investigation if I have reasonable grounds to suspect there was a conflict of interest. In your view, an apparent conflict of interest in applying the provisions of your legislation is something that is understood. It's part of training that you offer, and it is included in measures that an elected official must take in order to comply with your expectations. So, implicitly, an appearance of a conflict of interest is understood, but why not include it? That was a choice that was made. It's a 15-year-old code, and it was inspired by things that happened in Canada and elsewhere. That was the approach, to not define a conflict of interest. But does this not come back to what I said, that ethics requires more effort than law, and that it's not because something is legal that it is moral? And so your code allows you to act. It allows us to focus on prevention. We can explain what is included in legislation and what we offer as advice. Thank you very much, Commissioner, and thank you, Monsieur Thériault,